You're tuned in to Agriculture Today, and we start our Wednesday show with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Well, good to be with you again, Shelby.
Roger, talking about a few different things that are happening in the government or with the government. And first, the Federal Trade Commission filed a complaint against John Deere. And what is that?
Well, that's a case that concerns right to repair, and that's a concern of farmers that use John Deere products. Of course, John Deere is number one in equipment manufacturing. They have the largest market share, and so this is a big issue. When you buy a piece of equipment, you buy a combine, you buy a tractor from John Deere, the question from a legal standpoint is, what did you actually buy? Did they retain the rights to the software that runs the equipment, runs the engine, and runs the components, or did you just get a license for that? Did you end up buying it yourself? Did they retain the rights to the ability to restrict how that is repaired? Because John Deere also owns they put a lot of money into research and development to develop the technology that's in the equipment that's out there. And they want to make sure from their standpoint that it is repaired properly. And so therefore only their licensed dealers have the rights to repair that equipment. Now, from the farmer's standpoint, the concern for farmers is, well, if I have to go to a dealer and I'm under a time crunch to get a crop out of the field and I've got something that breaks down, I need it fixed immediately. I need the right to do that myself or have an independent repair shop that's nearby come out and do this, because a lot of these locations in agriculture are remote. A John Deere dealer may not be close. It may take several hours or days to get there. And you've got weather issues, you've got timeliness issues. That crop has to be harvested. So the legal system's going to have to sort this out. And now we've got the FTC, as you mentioned, has filed this complaint against John Deere in federal court in Illinois.
Where do we see this might be going?
Well, it was a split decision by the commission. 3 commissioners voted to approve going forward with the lawsuit, plus with the 2 attorneys general, one in Illinois and one in, I believe it was Minnesota. And 2 said, no, we need to wait, because they indicated, which is correct, that John Deere had memorandums of understanding that were either in place or being worked on with some major farm groups and certain states. And that was proceeding. And the 3 that voted to approve this in a 3-2 decision are now no longer there. They'll be replaced by the new administration. And so right at the last minute, as the prior administration was going out the door, here comes this complaint. And so in politics, it just kind of indicates that politics were involved in this. We'll see what the new administration does with that, whether they go through with this lawsuit or put a hold on it to decide either to settle or drop it and let the parties try to negotiate this. But this is a big deal. This is a really important issue for farmers on this whole right to repair, and the law has got to get its hands on this and get this thing settled quickly.
And Roger, something else you wanted to mention to us today, what the USDA interim guidance for biofuel feedstocks means.
Well, this is interim guidance on certain farming practices to raise corn and soybeans and grain sorghum. And some farmers are familiar with, or a lot of farmers are familiar with what's known as 45Z, which is the clean fuel production credit that's in the code. We were under 40B last year. Now it's 45Z. And that is a credit for producers of this so-called clean fuel energy. And so it would be the ethanol plants and so forth that can claim the credit. However, farmers can somewhat benefit from this. There's a flow-through aspect to it. But the interim guidance that USDA put out for biofuel feedstocks, from their standpoint, from the USDA standpoint, that information then has to be used by the Treasury Department, because the Treasury Department still has to write a rule to determine how they take that information from USDA and the models that the USDA has developed to feed into the formula for the calculation of the credit. So this doesn't finish off what's needed to be done to implement Section 45Z. That's still not in play yet, because we don't have the formula that needs to be set up by the Treasury Department. They still have to write their regulations on that. And, of course, now we're in transition. We'll have a new IRS commissioner. We now have a new Treasury Secretary. We still have to fill that IRS commissioner slot. The person's been selected but not done yet. And so we'll see what the new administration's position on this entire clean energy credit is. A lot of this came out of the law known as the IRA in 2022, the Inflation Reduction Act of 22. The new administration's policies may possibly eliminate it, but we'll see. We'll see what happens on this. But 45Z is not done. It's not in play yet, and that's what farmers need to know.
As we've seen some changes in Washington, D.C., have they made any maybe impacts on estate planning?
Well, we're in a year of transition, perhaps. This is the last year of the Trump tax cuts that started in 2018, and a lot of those provisions expire at the end of 25. And now the corporate income tax rate does not. That was made permanent. There were a couple of other things that were made permanent. But on the estate tax side of things, of course, the big concern for many people is what's going to happen with the basic exclusion amount. How much can I have in net worth at the time of my death, or how much property can I give away during life and not have to pay either estate tax or gift tax? And currently that exemption is $13.99 million per individual for 2025. If Congress does nothing, that drops to $5 million starting in 26 with an inflation adjustment, because that's going to be in 2011 dollars. So most of us think it's going to be about $7 million. So in essence, that exemption, that exclusion amount is going to get cut in half. And that will affect a lot of farming operations in Kansas, where the $14 million per person does not. $7 million does. And, for example, you take if we look outside of Kansas and look at the agricultural sector as a whole, we've got farm ground in Iowa that's selling for $22,000 per acre. And so, a section of land at $7 million exemption, you got a problem at that type of values. And even in Kansas, you take a 5,000-acre farming operation or ranching operation at $7,000 or $8,000 per acre. Yeah, we've got issues. And so it's pretty important as to what happens. And so in light of that, what we want to do basically from an estate planning standpoint for clients is we want to maintain as much flexibility in their plans as possible. And we often do that with types of trusts. And other concerns of farmers would be asset protection. I want to have access to my assets. I don't want to tie them up while we're waiting for Congress to set the rules. So I want maximum flexibility, still want asset protection, and then I want to be able to adjust to what the new law is going to be once we know what it is.
Are there old estate plans that maybe may not be as relevant anymore if we have changes?
Well, that's indeed possible, and this is a good year, one, if you haven't put an estate plan in place to get something done, and then secondly, to review your current plan with your practitioners and do something now, because I've got a number of techniques I talk about in my detailed Substack article, and various types of trust. One would be a standby trust where I'm creating the shell of the trust. I might put some assets in it, but I've got the legwork done. And when we get late in the year, if Congress is late on the legislation, then practitioners are going to be swamped and they're going to be busy and they're not going to have time to start from scratch and do a full-blown plan. So I want to do some of that legwork right now and have it sitting there. And then once I know what the rules are going to be going forward, then I've got my basic framework of a plan done. I've got the basic framework of a trust done. Then we can fund it appropriately depending upon what our goals and objectives are and what the law is going to be.
Roger, what are some key points then when it comes to estate planning, but also just watching what's happening in Washington, D.C.?
Well, keep an eye on what happens in Washington, D.C. What I'm told is that their goal is to do a big reconciliation bill and have it to the president by Memorial Day and signed by July 4. Those are rough deadlines right now. You'll hear talk about maybe 2 reconciliation bills instead of 1. The reason they talk reconciliation bill is because while it's easy to get a bill through the House on 51 votes, just a simple majority, you can't do that in the Senate. You have to have 60. And if you don't have 60, the only way around that to get a bill through on 51 is to do reconciliation. And it allows for limited amendments. It's a streamlined process. They can get it through quicker. And you also have to deal with what's known as the Byrd Rule, which means if you have a budgetary effect, if taxes are going to be cut, then that law has to sunset within 10 years. Now, I totally disagree with that process because they take a look at static the revenues in a static sense. So, loss of tax, if you increase tax, the thinking is that decreases revenue. Well, that's not necessarily true, but nevertheless, that's the rule that's in the Senate. So you want to watch that, and hopefully they tell us what the income tax as well as the estate tax rules are going to be sooner than later so that we have a window of planning opportunity.
Roger, if people are wanting to keep up to date with maybe what's happening in D.C. and hearing it from you, how can they do that?
Well, I will post some of these thoughts today that's going to go to Ag Manager, and also I have it on my own professional post, which is Substack, McEowen Ag Law and Tax .substack.com. But I'll boil these down and distill them. There'll be a version of that that'll appear on Ag Manager as well as on my blog.
Roger, I appreciate you taking the time to join us today.
Thank you, Shelby.
That was K-State and Washburn law professor Roger McEowen. I will link in today's show notes on agtoday.net, where you will be able to read more about these topics.